And there's also the question, I suppose, of what's called perks or benefits, where people are receiving in-kind benefits or allowances for travel and entertainment or perhaps other things that when you're trying to reconstruct what I call a true income, you're going to look at that and factor those things in as well so that the court, for instance, is aware of what the person has, the ability that the person has to pay support, correct?
Absolutely. And as I mentioned before, as part of our valuation procedures, we will look at the underlying books and records and try and identify what I previously called non-business expenses and, to John's point, perks that are really a personal benefit, not only for the business owner, but possibly even for the family, but otherwise representing cash available to the individual. So we would identify those perks for the business valuation and also use them in our cash flow analysis.
Okay. Let's segue into the last part of this discussion, and that is still on the income and expense side of things rather than the business valuation. In my profession, the idea of marital lifestyle or standard of living has become a key component of alimony, meaning that the demonstration to a court of how a couple actually lived, okay, as opposed to necessarily what money's moving in and out of a business, but how the couple and their family actually lived over a period of, let's say, 3 to 5 years. This marital lifestyle, being as important as it is in the alimony situation, is this something that you also get involved in?
Yes, it is.
Okay. And how would you perform an analysis or an investigation of a couple's lifestyle? Let's just say a person said, well, I can give you I know our expenses, but I don't know how to put them together, or you know, it makes no sense to me, or whatever. How would you talk to somebody like that?
First, we'll get direction from the attorney as to the time frame of our analysis, whether it'll be a 3-year period or a 5-year period or some other period of time. And once we have that understanding, we'll then again put together a document request list, and we'll be looking for bank statements, brokerage statements, canceled checks, credit card statements, lines of credit, or any other type of debt proceeds that may have been utilized in the period of time in which we're looking at, such as a home refinancing, and we'll gain an understanding as to where that money was utilized in the marriage. We'll take all of this information and boil it down into a detailed analysis by category of the marital expenses.
So, for instance, vacations the parties took, the kind of clothing they purchased, or how much they spent, is a better way of putting it, how much they spent on clothing, all of those personal kind of expenses, their transportation expenses, their overhead expenses, to create a whole as to how much was moving through this pipeline in a given month or year, let's say. Yes,
we'll have reconciled every penny of spending over the period of time that we're looking at, and categorize it, as John mentioned, into specific items, including child expenses and food at home and restaurants and health and beauty care and all of the typical expenses. But as part of this analysis, we'll also look at the savings. Did the parties put money away, or did they, or was it spent? And we'll be able to provide that information to the attorney, for the attorney to make determinations as to how savings should be contemplated in this lifestyle analysis.
That's a very good point, because just from the numerous cases that we've all seen, some couples are spenders and others are savers. So the fact that people were saving during the marriage, and you can isolate that savings component, as we call it, it allows me then to ask a court for a savings component when I ask for alimony, for example.
Yes.
Okay.
That's correct.
That's correct. And so that information you provide us by segregating that out allows me then to present to the court a cogent picture of why the court should award, let's say, my client a particular amount of alimony that includes a savings piece.
Yes. Okay. And along those lines, we'll also identify what may be considered non-recurring items. If during this period of time the parties made significant improvements to their home, which wouldn't necessarily be contemplated to continue if the parties had stayed together. We would isolate those dollars, or if they had made an investment in a vacation home over this period of time, or some other large expenditure that wouldn't necessarily be considered recurring, we'll isolate those items as well and provide that information to the attorney for the alimony and child support purpose.
Very good. Let me ask you, how do you charge for these services you describe?
Depending on the specific case, we will ask for a retainer that's appropriate for the facts and circumstances of the case. Up front, we'll get that retainer, and we charge on an hourly basis. But in our litigation department, we have staff at various levels, and we will make sure that the work is pushed to the appropriate level so that the lifestyle analysis that requires a lot of data input, we will push that to the appropriate level of billing to a staff person, a lower staff person, to make sure that we're cost efficient in our analysis.
So in terms of the retainer, that would be something the person would pay initially to hire you, and then you would go forward on this hourly basis and present bills to the client and the lawyer so that everybody's aware of what's being done and how much it's costing, correct?
That's correct.
Now, I know from my experience that there are situations where persons can't afford necessarily to hire a forensic expert. And the courts do allow an application to be made for the advancement of not only attorney's fees but expert fees if a person's not in a position to be able to hire an expert. And sometimes those are also the sources from which you ultimately get retained. Is that correct?
Yes.
Yeah. And I would also indicate for purposes of today that not only are attorney's fees available at the end of a trial to ask a court for attorney's fees to be paid by the other side, but the law allows expert fees to be requested at the end of a case, so that if there are outstanding expert fees and the court deems it equitable, they can order the other party to pay a share, or perhaps all in some cases, of the expert fees that you've incurred. Is that correct?
That's correct.
Okay. If a person wanted to, after seeing this, had any questions or wanted to contact you, how would they go about doing that?
They can call WithumSmith Brown in our Princeton office at 609-520-1188, or they could email me at thoberman@withum.com.
Okay. Very good. Well, thank you, Tom. It's been a pleasure having you today.
Thank you.
And I hope that this has been informative.
Thank you. I appreciate you having me.